CA CV18-0435 in the matter of Hamberlin v. State. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and we have discussed the case in conference. And with that, counsel, you may proceed.
Good morning. My name is Cameron Artigue. I'm here for the state of Arizona. The primary question presented is who owns a copy of electronic records that are collected by law enforcement in the execution of a search warrant? Does the duplicate copy of electronic records belong to law enforcement, or does it belong to the person who was searched? We contend that the Milstead case from the Supreme Court, it's now 35 years old, is controlling because the Milstead case established two categories here. One is property that existed at the time the warrant was executed. That belongs to the person being searched. They can keep it all. They can get it all back on controversion, and it's undisputed that that happened here, that Dr. Hamberlin, all his property was returned to him.
Counsel, why didn't the digital images exist? I mean, are you sort of making this distinction of printing it out, or the image existed? What is your basis for that argument?
Well, my argument is that law enforcement in executing a warrant can bring to bear a lot of tools, Your Honor. A photocopy machine, cameras, measuring devices, notepads, sketch pads. I'm not drawing any distinction along the lines you suggest. I'm saying that whatever evidence law enforcement amasses, whether it's recordings, sketches, notes, records, photocopies, that all belongs to law enforcement.
But you agree this does go a little bit beyond Milstead, where they're taking a photograph of something, and that photograph didn't exist before they went in. And in contrast, you're saying the copy didn't exist before they went in and made the copy.
The copy didn't exist in the same way, Your Honor, that if someone has bank statements from a bank and on a search warrant, law enforcement goes in, oh, here's the bank statements we want to look at. If they're on paper, I think we all agree that law enforcement can photocopy them, and those photocopies belong to law enforcement. What I'm saying is, if you go in and say, well, this person didn't get paper copies from Chase Bank, they got electronic bank statements from Chase Bank, this principle's the same. You can take those PDFs, well, the bank's record, I'm sorry, Your Honor.
No, finish.
No, that if the person chooses to get electronic bank statements and law enforcement says, ooh, this is interesting, this is what I'm looking for, law enforcement can say, I'm going to make a digital replica of this PDF file. I can do that. And that's the functional equivalent of a photocopy. For that matter, law enforcement could pull up the bank statement on the screen and take out a camera and take a picture of that. And that's the Milstead case.
Right. I think that's the point, right? So Milstead, you have officers descending on a perp's house, let's say, cameras in tow.
Yes.
And taking pictures, and those are not property to be returned. Now, isn't that different than images on a camera seized by officers? And what I'm most interested in, and even looking at your banking example, is sort of the ownership interest, the possessory interest. In one instance, you have an officer who is creating images from nothing. In another, you have going to a bank and asking them to, it's certainly not, the bank that belongs to, it's not the piggy bank of this defendant, it's a bank, a third-party institution. But then here, in 2019, how can we say that seizing a camera isn't, as property, isn't also seizing the images, what are digital images?
Well, you may be seizing them. That's what Carpenter's about.
Returning, I'm
It
sorry.
may be an expectation. It may be a search. You may need a warrant. Those are Fourth Amendment issues.
Returning.
You know,
When
but
we're talking
it's who
about
owns it.
13. Right, but I want to stay on that, on ownership. But again, looking back at 133922, that the magistrate shall cause the property to be restored to the person, and looking at that word
Yes.
property,
Yes.
I see a difference between the bank example, going to there and getting the, and then the Milstead case versus this person's camera and the images that he created, not police officers descending on the house with camera and
Well,
tow.
are you suggesting, Judge, that if the officers go and find a camera, let's say it's an old-fashioned film camera, and there's a roll of exposed film on that camera, and they take that on the warrant and say, ooh, this might have evidence on it, and they develop those pictures, that's the and they make prints that belongs to the person who was searched? Because that's what you're suggesting, Your Honor, and that makes no sense.
Yeah, so anything I'm suggesting is to get to the right result.
Yes, yes.
But let's talk about that. What if it was a famous photographer?
Well, you could be, you
Is
could
that
be
his property or no?
It could be his property. But the copy belongs to law enforcement. You could be a famous diarist who keeps a private personal diary.
Belongs?
You know,
I have a statute here that says return the property.
yes,
Is it where in here does it say except for digital images?
it doesn't. But digital images are property, and when you duplicate it, it becomes the property of law enforcement, just like a photocopy becomes the property of law enforcement. I mean, let me try this one, Judge. If in the olden days you went and executed a search warrant and there was a cassette tape, okay, that has an interesting conversation on it, law enforcement could duplicate that cassette tape. We called it dubbing back in my day. Law enforcement would own that cassette tape. The fact that that conversation is contained on a MP3 file should make no difference. It doesn't say, well, I mean, the owner of the cassette tape has no different property interest than the owner of the MP3 file. And in both cases, law enforcement can say, we're going to duplicate this file for our law enforcement purposes.
Okay, well, that's not Milstead.
No, it's not. No, I agree. That is not Milstead.
Let's keep that right there, because I thought that you started off with, one of the first few sentences was Milstead. But if we're going to look outside of Milstead,
well, I guess
you're saying that there's just sort of an area of law that you want to sort of graft, if you will, onto this statute and its use of property.
Yeah, I think the way I would link up Milstead to this case is what I said before, Judge, is that Milstead says that photographs taken by law enforcement are the property of law enforcement. I guess my point is, if you have 1,000 emails on a server, and it's agreed that, hey, law enforcement can pull up those emails one by one on the monitor and take 1,000 photographs of each one and own them that way, but they can't just duplicate the server, because that would remain the property of the party being searched. What we're really litigating is how inconvenient we're going to make this for law enforcement. I mean, if you can say, well, no, if you want copies you can keep, law enforcement, you need to pull them up one by one and photograph them.
Right, well, that's an interesting point, because Milstead seems to say that here they could have pulled them up each and taken a picture of each, and that would have been fine.
Yes.
But that didn't happen. This isn't Milstead.
No. But what I'm saying is the difference between photographing 1,000 emails and saying, you know what, we're not going to spend 3 days at your house executing this warrant. Let's just take the server back and duplicate it. That should not make all the difference in who owns the digital duplicate. That it is the same thing. And if you say, well, if it comes off a computer, law enforcement, I mean, could a law enforcement officer copy it over by hand If you pull up a PDF of the bomb recipe and say, wow, that's incriminating, I'm
But
interested in this
counsel,
PDF.
let me jump in and
You
ask a
know?
question. Is it the defendant's duty to make it easier for law enforcement?
Absolutely not, Judge. Absolutely not. But the law enforcement is entitled to make duplicates, copies, and maintain records. I mean, that is necessary to enable law enforcement to gather evidence for prosecution. Let me pivot to this point, because if you allow the controversion action to reach into the government's evidence room, you really equip the defense counsel with something that's far more powerful than a motion to suppress. Because your remedy isn't just inadmissibility of the evidence. It's, government, you can't possess this. You have to take it out of the evidence locker and destroy it.
Well, it doesn't say destroy, and the government could presumably get a warrant, and if the warrant's supported by probable cause, could get the evidence, unless you're saying there would be an incentive to go and destroy it. But we're assuming now that there wasn't probable cause for the search, and so if we assume that, then the government now has something that they weren't entitled to.
Well, but that's the issue for the suppression motion, Your Honor. What I'm saying is, if you say, before a criminal charge is filed, if all that's happened in the field is a search warrant's been executed, and you say, gosh, I don't want to wait for a criminal charge. I'd rather head this off before it gets to a grand jury. I don't want the grand jury to see this evidence. I'm going to file a controversion action and take it out of the evidence locker so that the grand jury never can see it. Now, that is a much more potent weapon than a motion to suppress. And that is unknown.
Isn't the other side of that coin that law enforcement may just be very careless with their search warrants and just say, as long as we can get that property and take a copy of it, who cares if later the search warrant is found to have been insufficient?
Well, that's true, Your Honor.
We've got our copies, so really.
But that's the government always. That's what suppression motions are for. And this court can't presume that, well, motions to suppress, where we enforce the Fourth Amendment, those aren't really important proceedings. Of course they are.
But that's a separate proceeding. You say in your brief that Judge Myers erred yet again by ordering the department to turn that evidence over to Hamberlin, and then further you say ordered the department not only to return Hamberlin's seized property, which it had already done before the hearing, but also to purge from the department's computers the copies of digital data that it extracted, and then that he precluded the state from offering these data as evidence in its prosecution. But this was not an order suppressing the evidence in some further criminal matter, was it? And aren't there any other ways that the police can seek to obtain that evidence?
Well, to answer your first question, no, it's not a motion to suppress. It's broader than a motion to suppress. Because saying you can't admit it is less than saying you can't possess it.
Did Judge Myers say you cannot admit it in a criminal case, or did he say return what you have right now?
He said return.
But he didn't say you may not go by any other means. You may not obtain this evidence.
Well, I guess you could execute a second search warrant, Your Honor. But then you're just back to where you started. I mean, by then the defendant will have gotten rid of the evidence, or they certainly won't have printed it out and said, well, now I've got hard copies for when you come with the second warrant.
That's the rationale, is that they might have gotten rid of the evidence, so you're allowed to keep.
No.
I'm not sure what.
Judge Cruz's question was.
No, I understood. Yeah. And you said, well, then you have to go back and get another warrant. Is that, again, the convenience argument, or? No,
it's not the inconvenience argument. What I'm hearing is, even if after the controversion motion is successful and the government must return the evidence and return the duplicate electronic evidence, isn't there another way the government can go get this evidence again? And the only way I see is for the government to go back to the premises on a second search warrant.
With some presumably more persuasive evidence. We're operating under the assumption that there was not probable cause. So if we accept that, then the government has
No,
property that it was not entitled to. If we accept that there was no probable cause.
but even if there's no probable cause, Your Honor, you still can't, or the judge cannot order a remedy. He cannot order the restoration of property that does not belong to the person searched. I mean, that is beyond the scope of the statute. That's the point, is that,
And so the government can go through, if it takes someone's cell phone, the property is simply the phone, and if we duplicate everything on the phone, the government can go and look through, let's say, just no question, there's no probable cause. You take somebody's phone, you just immediately make a copy of it and do whatever you want with it, and there's no problem with that. I gave you back your phone.
well, we're talking about, obviously you're going to have big suppression issues. You probably have tort issues, and we can talk about, qualified immunity and all that. But in terms of 133922, when the government gives you back your phone in exactly the form that they took it from, no, that's as far as 133922 extends.
Okay, we're only raising that issue because you raised in your opening brief the argument that it was, that you were precluded from using the evidence in the prosecution down the road.
Well, you can't, I guess it's just a syllogism. You can't introduce evidence that you do not possess. I mean, you're right.
But aren't you saying essentially, there's no other way we can get it? If Judge Myers rules that we have to return this, then we cannot go forward with a criminal prosecution. And that's just not correct, because there are other ways to lawfully get it. Or maybe if you can't get it lawfully, maybe you shouldn't have it.
Well, I think that's assuming a result, Your Honor. Yeah, I mean, you're right. There is the second warrant, but it makes no sense to say we're going to extend beyond the scope of 133922 because by the time that controversion hearing is concluded and any appeal thereof is concluded, the state can just go execute a new search.
I think you're the one who's arguing to extend beyond 3922 by saying, that we shouldn't have to go and get this second warrant. But looking at this statute and the word property and Milstead, you would concede that you're asking us to extend the law somewhere it hasn't been taken to in this state.
I'm asking you to apply Milstead to electronic records. I agree with you that this is not, on all fours with Milstead. What I'm asking you to conclude is that electronic property is the same as any other property, and that the Fourth Amendment does not modify or affect the state law real property rights. That's not what the Fourth Amendment does.
And I think you're arguing then that the owner of that camera has no possessory interest in the contents of that camera, such that they are what we would call, and we all learned in law school, property.
No, I think that the owner of that camera owns the camera, and I think the owner of the film in the camera owns the film in the camera. I think if law enforcement takes out the film and makes a print and says, let's put that in the evidence room, that print belongs to law enforcement.
Counsel, but let's get back to the example that Judge Katani raised earlier. Let's say that what was seized here was an iPhone.
Yes.
Latest model iPhone. And, the person wants his phone back, and you hook it up to a computer, and all of the information in it is copied, and here you go. Here's your phone. I've returned your phone, so that's the end of it. We're living in a different era, and so that's the question. Is that property? Did you keep property out of that phone?
Our position is that when the iPhone is returned, unadulterated, in its original condition, that is as far as the statute extends. It's the same as, my briefcase. When I'm carrying my diary, my most private papers down the street, if law enforcement says, hey, we want to take everything in your briefcase and make photocopies of it, that may be problematic for many reasons, but the copies they make belong to law enforcement.
So you can use those copies, search through to find probable cause. If you don't have you didn't have probable cause to seize it, and there's no other independent way to get probable cause other than to search through the property that you were not entitled to have taken in the first place?
No, I'm not saying that, Judge Catani. I'm not saying the fruits of the search need to provide probable cause for the search. Probable cause is a separate question. I'm saying even regardless from the probable cause issue.
But take it, assuming there was not probable cause. So then you can now, you've downloaded the contents of the phone. You can use that to establish probable cause to search more, to get the phone again.
No, you cannot retroactively justify the search. My point is that if it's determined, hypothetically, that
But
there's no...
I'm not retroactively, you're establishing now probable cause to charge someone with a crime. You were trying to charge them with a crime initially.
Oh, yes.
You didn't have a probable cause, but now you've downloaded the entire contents of the phone, and you can just use that.
Yeah, as stated, they're going to have a very strong suppression motion probably, but that's the way our system works. I mean, yeah. But insofar as 133922 operates, when you return the property that was taken at the time of the search, you've given the person all they're entitled to. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the Court. My name is Justin Ackerman, and with me at council table is Lori Vopel on behalf of James Hamberlin. I think some context would also be relevant to the discussion that's just been held, but I do agree the most important issue before this Court is whether copies of someone's electronic information is their property, and it absolutely is.
Counsel, would you concede, though, that under Milstead, that the police could have taken pictures of all of those digital images, and our Supreme Court has said that is not property under this 3922 to be returned?
The answer is no, and the reason is it's an oversimplification of what's happened here. In the context of taking a photograph, you are taking, let's just say they're taking a photograph of a document. You are literally taking a copy of just what is on the face of the document itself, but that is different than intellectual electronic property here, and it's particularly important for this case because the very thing the state sought was not only what was on my client's various computing devices, but also metadata and geotagging data on photographs, things that do not exist in a photograph that's taken by law enforcement of a static object.
Well, but my question was, if they had taken pictures and returned everything else, that falls under Milstead. You wouldn't have any geodata or whatever data. Would that fall under Milstead? If a police officer just brought up each image and took a snapshot, how is that any different than Milstead?
It wouldn't be different in Milstead, but that's not what happened here, because what happened here is...
Well, right, and I'm going to get to that.
Sure.
But you would agree then that the police could do that under Milstead?
Well, Milstead involved the photography of physical items. Nothing was photographed in this case of a physical item. In Milstead, they took
Could it
photographs
have
of the
been?
crime scene.
Could it have been?
I don't, unless they pulled up the computer and each page took photographs of what was on the computer
So
or on the iPhone, that
they
didn't
have done
happen
that?
here. What happened here was the reverse of a normal search.
Right. We're asking a hypothetical.
I
We know what
understand.
happened. We've read the briefs. Could that have happened? Could they have taken photographs of the information?
No.
Or for that matter, had someone draw and take pictures that way, just the old school way. Would they have been able to keep their product?
If they had taken their own personal notes, something that was within the plain view of the law enforcement officer, yes, they could have, but that's, again, not what
Okay,
happened.
but not, even assuming it's not in plain view, if I pull up something on the computer and look at it, maybe if we take a picture of what's on the computer, or take it another step, I just memorize what's on the computer page. Are you somehow entitled to my memory? How do you get that out of my memory? Isn't that a different remedy for what you're seeking, as opposed to you get all your stuff back, you don't get, if it's in my brain, you're not getting my brain, obviously.
Obviously. Yes, Your Honor.
Not worth a lot, but it seems like you have a different concern. You want to keep me from using what I have memorized from your information. That seems like a different lawsuit than give me back my property.
Well, I think I understand that the court is posing hypothetical, but I think the facts and the context of this case are key to what has happened here, because we're
Well,
talking.
I think we're going to get there.
Sure.
But we're just taking one
understand.
step before we get there.
But yeah, if you could just go through, why would it be different if you just take a screenshot of everything on the computer? How different is that from Milstead?
That's in line with Milstead, Your Honor.
And so why is this next step? We've essentially made a copy of everything on there. We've just duplicated at a very high speed. We have a copy of everything that was on there.
Because you're now divested from someone actually reviewing the document and taking a photograph of it. And again, you're ignoring, that would be ignoring the realities of what digital information is, as opposed to physical copies of certain items. And the various things that are contained within a digital file that don't exist in the physical file.
So you're saying Milstead, maybe inadvertently, but accounts for the development in technology by protecting what is just an image, and I guess it's a piece of paper or a Polaroid, but whatever, versus this data, which has, and I'm not an expert on that, but all these side compartments that tell you more things, that is accounted for in Milstead.
No, because what happened in Milstead was, as the court has recognized, the law enforcement has taken their own photographs of items, things that the photographs themselves that law enforcement took post-date the search.
I got a better question for you.
Sure.
The application of Milstead doesn't on its face compromise or necessarily implicate the concern you're raising. Milstead can be applied on its own and it doesn't implicate any development in technology.
I disagree with that, Your Honor, respectfully. The case in Milstead was, again, photographs that were taken after the fact, after property that had predated what law enforcement had done in that case.
There's not a copy at the time we go in. Law enforcement goes in. There are no copies.
Well,
they make a copy.
I think a copy is, again, an oversimplification of a photograph. A photograph is not a copy of the information. It's a photograph of the information. And I know that's sort of dancing on a technical hair, but it really matters when you're talking about a copy of digital information.
Right. And so what I'm saying is Milstead didn't envision that next step. It was just a duplicate, a copy of a photograph. It didn't go beyond and say that you're entitled to the guts of data that has much more.
I struggle to agree with that only in the way you're phrasing it, because a
I'm
photograph is
surprised
not a
because
duplicate.
that's exactly, I thought, what you'd be arguing, is that Milstead doesn't cover this case because we're talking about data that has all kinds of things additional that aren't included in a piece of paper with a duplicate.
Yes, Your Honor.
Yeah, but if law enforcement just goes in and pulls up the information, looks at the GPS information on someone's phone, and says, oh, this is where the person was on this date or that date, you can't get that information back from the officer.
No.
He or she
you
has
can't.
that, and you just get your phone back.
Yes, Your
So
Honor.
So I'm struggling with why that's different. You can try to suppress that. You can file a suppression motion, file a civil action to say you've violated my rights, or I have a privacy interest in that information. But in terms of I get my phone back, you got your phone back. And he hasn't done anything other than memorized what was and looked through and saw some GPS information that's different than what could have been taken in a photograph just walking into the house.
Well, because what was taken in this case can't be, I don't think, could be readily observed or memorized or written down. I mean, there was 100,000 photographs that were copied.
And so does it turn on how
The
long
volume-
they have to stay there? We want law enforcement to go in and take pictures of
I think
everything?
the volume of the seizure impacts the decision here. I mean, the fact that the vast amount of information that can be downloaded just from an iPhone, let alone the various things that were taken here, significantly impact that analysis.
So what is the detriment to your client? If he received his equipment, if he received his digital data, What is the detriment?
It's his property interest in being the sole ownership of the information that's contained on those devices. You know,
Isn't that something that can be vindicated through some other mechanism other than saying the statute tells me I get my property back?
Not in this case, because what happened in this case was his property was seized. The government held on to it for 5 months. They did not file criminal charges. He had absolutely no other remedy to get his information and his property back.
But he did get his property back. The government gave him back his property.
Only after the motion to controvert was filed as an attempt to short shrift those
So after he
proceedings.
gets it back, then what is the detriment?
That the government is still in retention of his personal information.
But
And
he
how
can-
does that harm him? I'm sorry.
No, I'm saying he can file presumably a motion to suppress. He can file some sort of other civil action to try to recover or to claim an invasion of privacy.
Again, he can't file a motion to suppress because at the time the motion to controvert was filed, there's no criminal proceedings.
Outside of a criminal matter, which may or may not be filed, what is the detriment? Are we afraid the police is going to sell the photographs? What is the detriment?
2 points. One, just for the clarity of the record, there is a criminal proceeding ongoing. So to the extent the state has asserted they wouldn't be able to bring a case without this, they have. It's ongoing right now. In fact,
And
Well,
that
but
means
they've
you have
said-
a suppression motion can be filed to the extent something that was used that was improperly seized.
it could be, but again, we're far afield from that now. That wasn't the case at the time that this was filed. And for anybody else in the future, when the state obtains their property, or even a third party when the state obtains their property, and then decides, especially with a third party, when there's never going to be a criminal trial, ever.
So, I mean, is the question, we have a statute, uses the word property, whether or not that includes both intangible and tangible, or
May I
What-
interrupt you on that point really quick, Your Honor? I don't mean to be rude, but I just want to make the important point that Title 13 does define property, and it defines it as intangible or tangible. And it's within Title 13, and so is the statute.
what's that statute number? The
It is
definition?
13-105, sub number 37.
But you're now not asking for intangible property. You're asking for copies is presumably a tangible property at this point.
To the extent that copies exist, they would be in electronic form. In to the extent the government, I guess, prints them out, they would be tangible, and you could ask for those back, too.
One thing I found interesting, and if you can expand on it,
Sure.
is the difference between data and a Milstein-like photo session. And that this data has metadata. What kinds of things are available? What information is available from data that wouldn't be available from a Milstein-type photo shoot?
Sure. And it's key to this case because it was what the government was after. For example, one of the photographs taken from my client's camera. In today's current technology with the way cameras work, and I would assume it would be with the level of sophistication that my client has with his photography skills, when a camera takes a picture, especially on an iPhone these days, what's embedded within the photo is not only the photo itself and what it depicts, but also a location of where the photo was taken. And the state had a particular interest of collecting the photos to see if they could track where my client was to determine whether or not he was in violation of the game and fish hunting regulations, assisting someone allegedly of doing a bighorn sheep hunt. If the court looks at the actual search warrant, the search warrant asks for this information specifically. It asks for all cameras, telephones, computers, laptops, etc., so that they can give it to a qualified individual to perform extraction and analysis of stored files, photographs, videos, internet history, and other social media, pictures,
Which
text.
page of the warrant is that?
This is on page 3 of the warrant.
And why isn't that just the subject of a motion to suppress then?
Well, the question was, what is the difference between a physical piece of property and data? And the state was after this very thing, and as I was getting to it, they're looking for the metadata. It's mentioned in the
But if
search
they go
warrant.
in and they look for it right there at the time, they pull up your iPhone and actually look at the images and get some, and if it tells on the phone this was taken, even gives you the location where it was taken. They have that information. It seems like the statute, this statute that we're talking about, just gets you your phone back. You still have to file a motion to suppress to tell them, well, you guys saw some GPS or whatever the data is on that phone, and that needs to be suppressed. That, it still seems to me that that's a different argument than give me back my phone.
And again, Your Honor, I don't want to be a broken record, but in that circumstance, it would be within the plain view of the law enforcement officer. They would be
Well,
observing
they had to
the
go in
information.
and they had to go in and do some. They had to go in and open the phone and look at photos. So it wasn't necessarily plain view walking in. They actually picked up the phone and went through, and maybe they didn't have a warrant, maybe they needed a warrant, but all properly the subject of a motion to suppress.
If there were ongoing criminal proceedings, I think this case would be in a different posture, but that wasn't the case at the time that the motion to controvert the search warrant was filed. That was the sole remedy available to my client to obtain his property back.
So it all goes back to the criminal matter.
I'm sorry, in what context, Your Honor?
Well, aren't we really looking at the reasons for the request? Is your client requesting the property because he wants it, needs to have it, he needs his cameras to do whatever it is with them, or your client wants these copies or this information because he doesn't want the state to have it?
I think any concerned citizen wouldn't want their private information in front of or in retention of anyone other than themselves. I think everyone has a right, a property interest right, in their own personal confidential information. And just to add context to that, it wasn't just photographs we're talking about here. We're talking about my client as an endodontist. He has confidential, doctor-patient privileged information in these things that were seized. He's also a Mormon bishop. He has confidential clergy communications that are contained therein.
Right. Your point is that a citizen of this country has constitutional rights. Is that what you're saying?
And they have statutory rights under the statute.
Well, right, but we were talking about your interest in not having the government have your information.
Mm-hmm.
And so, are you saying that there's a constitutional basis for that, and it's not, there's no sort of exception that the government can have some information if they don't use it, or?
I don't believe so. I mean, although it wasn't before this court, because there was never any attempt to limit the scope of what the government could retain, there is a body of case law out there that even says when the government executes a valid search warrant, which we have not had here, the government still cannot retain information that's not relevant to its search, like the photographs that we're talking about here, personal photographs or personal information and that sort of thing. So cases have started to address.
But under Milstead, you would have, let's say it's just somebody's personal diary, and
Mm-hmm.
they take pictures of 10 pages of the diary. That would have to, if your diary's returned, you would say you have to return those copies of the 10 pages of the diary.
If those copies have absolutely nothing to do with the law enforcement's investigation, under what I was just referencing, yes.
Well, what are any photographs that if they come in and they want to document what was in, they take the picture so they can show that they didn't change anything later at trial. This is what we took. This is what was in that book. It's confidential information. None of us want our diaries to be made public, but it's confidential information. They've taken a photograph under Milstead. Do you get that back, or do you have to file some other type of proceeding?
I think if you put that in the context of this case at the time in which this was filed, I think you get it back because it's an interference with your own personal information. I think every person has a right to keep their information confidential, and their right to destroy or delete their own information, which that would be an interference with that right if the government's retaining a copy of that. A couple things that I'd like to touch on very briefly, although I haven't heard it much argued today. To the extent the state's arguing a Frank's standard that be applied to this, it was waived. It was never argued before the trial court. It was never argued during the evidentiary hearing, the motion to controvert. It was never argued in any proceeding before the trial court whatsoever. And it's completely something that's derived out of an exclusionary rule, Fourth Amendment jurisprudence. That has absolutely no application to this statutory remedy that's extremely specific as to what needs to occur. It provides that the court take testimony on its own. They've made some arguments that the court shouldn't have considered something beyond the four corners of the search warrant affidavit, but the statute itself expressly tells the court that it shall hold an evidentiary hearing and consider evidence, and that's exactly what happened here. I'll leave it to my brief to describe the intricacies of why there was not probable cause in this action, unless the court has any further questions.
We do not. Thank
Thank you.
Counsel, we thank you for your arguments. This matter, as well as all matters conferenced this morning, are now under advisement. We will issue a written decision in due course. Thank you. We're at recess.